The New Jersey Center for Tourette Syndrome and Associated Disorders, its directors and employees assume no responsibility for the accuracy, completeness, objectivity, or usefulness of the information presented on our site. We do not endorse any recommendation or opinion made by any member or physician, nor do we advocate for any treatment. You are responsible for your own medical decisions. Now I'm going to turn over the introductions of our speaker to Martha Butterfield, the webinar coordinator of NJCTS. Marty?
Thank you, Kelly, and good evening, everyone. Welcome to tonight's presentation. Thank you for joining us. We're pleased to be able to bring you the second and final part in our series of 2 webinars on school choice. We began the series on June 22nd with a discussion on charter schools. That webinar, as well as all of our presentations, are available for download on our website. Tonight's presentation will focus on private schools and the services they are required to provide. Our presenter for both parts 1 and 2 of our school choice webinar series is attorney Rebecca Spar. Rebecca is a partner in the law firm Cole Schatz in Hackensack, New Jersey. She has a federal and state court litigation practice in employment, education, and disabilities rights law. She served as law secretary to the Honorable David Landau of the Superior Court of New Jersey, the Appellate Division. Rebecca is a committed and experienced child advocate who for 25 years has worked to ensure that school districts and both private and charter schools comply with education and anti-discrimination laws and regulations. Furthermore, that they provide appropriate educational services. They make needed accommodations and modifications for disabilities and prevent discrimination against those with actual or perceived disabilities. She also serves on the board of our organization, the New Jersey Center for Tourette Syndrome, and has in-depth experience in the specific issues faced by students with Tourette Syndrome and associated disorders. Rebecca, welcome back. We are so pleased to have you present on this topic, which is a very important one. Now, without further introduction, I'll turn tonight's presentation over to you.
Thank you, and good evening, everyone. In this webinar, we're going to be looking at what the rights of children with Tourette syndrome or other associated disorders who are attending or applying to attend a private school in New Jersey. I'm going to be talking about 3 federal laws and referring briefly to the New Jersey state law. The federal laws that I'll be talking about would also or may also cover private schools in other states, but I'm going to be talking today specifically about New Jersey private schools and what the rights of your children would be in these New Jersey private schools. Now, during my presentation, I'll be discussing some actual examples of how the state or the federal laws have been applied in particular situations, but this shouldn't be construed as legal advice on how the laws would be applicable to your child. And if you have some concerns and need legal advice, you need to consult an attorney. There are different types of private schools, and what your children's rights are in private schools is going to depend on what kind of private school your child is attending, as well as how they came to be attending that school. There are religious private schools and there are non-religious private schools. And there are private schools that receive federal funding and some that do not receive federal funding. And that fact will influence your child's rights. And among non-religious private schools, some private schools have been approved by the state of New Jersey for the placement of students with disabilities, and that fact will influence your child's rights, and we'll go into detail on how it would influence them. The first statute that we're going to be looking at is the Individuals with Disabilities Education Act. And if your child has a disability and has been classified in a public school, then you may be familiar already with this statute. This is a statute which requires public schools to identify and evaluate children who may have a disability and need special education and related services. And if eligible, would get an IEP, which would provide the student with an appropriate education in the least restrictive environment. Now, if you place your son or daughter in a private school, you will have the right to some of the benefits under the Individuals with Disabilities Act, but not the same full benefits that you would have if your child is attending a public school. For example, if your child is entering the first grade in the private school, and IDEA, or the special education law, covers any type of private school, including a religious school, and your son had done well in kindergarten, and you're looking forward to him doing well in his first year in the private school, then at the first parent-teacher conference, you're told by your child's teacher that he's very bright, doing well socially, but he seems easily distracted and is having difficulty focusing in class. So you talk with some of your friends who suggest that perhaps the difficulty is that he may have an attention deficit hyperactivity disorder and he needs some special education services. So your first question is, does he have a right to some special education and related services through the Individuals with Disabilities Act while attending a private school? And the answer is, he may be able to receive some special education and related services. The first thing that needs to be done is an evaluation. And if the evaluation shows that Chris has a disability that adversely impacts his education, then he may have a right to some special education services, whether he's in the religious or the non-religious private school. And as I said, he will not, however, have the same rights as if he were in the public school. The school district in which the private school is located has responsibility for identifying and locating and evaluating all children who are suspected of having a disability and who are enrolled by their parents in private schools. And this is called child find. So if you reside in Teaneck, New Jersey, and you sent your child to a private school located in Paramus, New Jersey, then Paramus School District is responsible for child find for your child. If you reside in Teaneck, New Jersey, and you sent your child to a private school located in White Plains, New York, then White Plains School District would be responsible for child find. Now, typically, the private school will refer a child for an evaluation if it appears that they may be eligible for special education. If the private school doesn't, and you want your child evaluated, you can send a letter to Paramus School District or White Plains, if that's where you're located, explaining that your child is attending a certain private school and asking that he be evaluated. Now, what happens if Chris had difficulties for the entire first year and no one told you that he had a right to be evaluated and possibly receive some special education and related services? Is there anything that you can do? And the answer is yes. You have a right to file a due process petition with the New Jersey Department of Education against the school district in which your private school is located, claiming that the school district failed in its child find responsibilities. Now, you could always, if you don't want to start with a due process petition, you could always contact the school district and ask for the evaluation and ask if they would give some makeup services for the time that your child wasn't getting, hadn't been evaluated and wasn't getting any services. Also, if you didn't agree with the results of the evaluation, if they found that your child was not eligible and you believed that he was, you could file for due process. Now, if you don't want your child evaluated and the private school says, look, we think your child has a disability and needs to be evaluated, and you disagree, you don't want to have him evaluated, you can just refuse to sign consent to the evaluation. They cannot evaluate your child without your signed consent. And if you don't agree, don't sign it. And the school district cannot take any legal action to compel you to consent to the evaluation. So now Chris has been evaluated and he's been found to be eligible for special education services. So what services is he entitled to? Well, if the private school is located in Paramus School District, then Paramus has to spend an amount to meet its obligations to children attending private schools that have disabilities, an amount that is equal to a proportionate amount of the federal funds made available to Paramus under the Individuals with Disabilities Education Act. And in case that sounds complicated, which it does, an example is if there are 100 children with disabilities attending public and private schools in the area served by Paramus, and 3 of these children were placed in private schools by their parents, then Paramus has to allocate 3% of its federal grant for special education to the students in the private schools. Now, this is only 3% of its federal grant, and most of the money for special education comes from state and local school districts. So it is not a lot of money. So who decides how the money is spent for the special education? And this is the big difference between if your child was in a public school. The public school has to have a process for consulting with private school representatives as well as parent representatives to decide in general how the special education and related services money will be spent, and how and when decisions will be made, and what will happen if the funds are insufficient to serve all of the parentally placed private school children. So in other words, the services are limited to what the public school ultimately decides it's going to provide to the private school children in general, not to your child specifically. So for your child, a service plan will be developed for if your child is found eligible, and a representative from the private school as well as the parent and sometimes the teachers attend a meeting, and a service plan includes the specific services that will be provided in light of the services which the public school district has decided it will provide. And those services are typically some supplementary instruction, some related services. There are modifications put into the service plan, those sorts of things. And we'll go into a little more detail on what kind of other services might be available. If they're going to provide the services somewhere other than at the private school, then the public school would have to provide transportation to and from. And of course, if the private school is a religious school, the special education and related services are to be secular, neutral, and non-ideological. And the services can be provided on the premises of the religious school to the extent appropriate with law, which they can be provided. Now, what happens if you get a service plan for your child, but you decide that you feel that those services are not sufficient? Do you have a right to a hearing or mediation under IDEA? And the answer is no. That if you have placed your child in a private school, you do not have the right to an appropriate education from the public school district as your child would if he or she were placed in the public school. You have a right to some of the specific services that are a proportionate share of the federal funding. So it is different, and you cannot file a due process or mediation if you don't believe those services are sufficient to provide an appropriate education. Now also, New Jersey has its own auxiliary and remedial services that are required under New Jersey statute. So those are commonly referred to as Chapter 192 or remedial services, auxiliary services, and 193, which are the remedial services. So the auxiliary can include compensatory education, English as a second language, home instruction. The remedial includes the evaluation, as well as supplementary instruction in speech language. Now, if you are attending a private school in New Jersey, but you do not live in New Jersey, the only one of those services you're eligible for are the evaluation services. And if the private school doesn't bring it to your attention that those services are available, you can ask for the application, submit it to the private school or the public school where the private school is located to get the services. But as I've seen, private schools are usually making you aware that those services are available. And private schools who participate in the 192 or the Chapter 193 programs have to comply with the Civil Rights Act. Now, in addition, New Jersey statute says that whenever a school district is required to provide transportation to students attending a regular public school program, the students attending private schools may be entitled to some transportation services if certain conditions are met. And an elementary student has to be more than 2 miles from their home. A high school student has to be more than 2.5 miles. The private school must be nonprofit. It must be located in New Jersey. There are some counties like Warren. There are some exceptions. And it can be located no more than 20 miles from the student's home. And again, some of the counties, in some instances, it's 30 miles. Now, the amount, however, that you get is not that much money. What the law says is that if the public school district has a route and there's room on that route, and it's not going to cost them any more than this maximum expenditure, which is around $884 for 2015-16, then they can put the student in a private school on that public route. In most instances, there is no space, or it costs more than that. So it ends up that the parent is able to get reimbursement for up to that amount per year. So it's not a great deal of money. Parents of students attending private schools can also request loans of textbooks, and you make your request to the private school or the district board. And this tells you, and those textbooks remain the property of the District Board of Education. So those are, if this is a pure private placement, private school placement, in which you just want your child to attend a private school, and so you place them there, but he or she needs a little bit of supplemental support, then those are the kinds of services that could be provided under IDEA. Now, another situation is where your child, for example, has Tourette Syndrome and associated disorders, was found eligible for special education, and was placed by your school district in a private school, that the New Jersey Department of Education had approved for the placement of students receiving special education services. So in that situation, of course, your public school has to continue to provide your child with FAPE, and you have all the rights as per the public school that you would have if your child were attending school in the public school. You would have a right to IEP meetings and notice and due process and mediations and so on. But as far as the private school is concerned, let's say, for example, your son went into the private school, everything seemed to be going well, then he began experiencing some discipline issues, and you're contacted by the private school and you're told that his enrollment has been terminated effective immediately and that he's going to be placed on home instruction until a new placement can be found. So what are the private school and your local school district's obligations? Well, in those circumstances, both the private school and the public school are obligated to comply with all of IDEA's requirements. And you as a parent have all the same rights provided and all the same protections provided to parents and students by IDEA. And this includes what must happen before the student's placement can be changed. And this means that an IEP meeting needs to be held to discuss the private school's concerns about the appropriateness of the placement, and the IEP team needs to decide whether the placement should be changed, and if so, what it should be changed to, and must give you 15 days written notice of any decision to change your child's placement. So just because your child is in a private school and has been placed in that private school by your school district, it doesn't mean that you lose those kinds of procedural protections to prevent your child from just being summarily terminated from a placement without first having an IEP meeting. Now, there would also need to be a manifestation determination to determine whether the behavior is a manifestation of your child's disability or was due to failing to implement his IEP. And if you, within 15 days of receiving the written notice of the change in the IEP and placement, if you file due process or mediation, then your son's placement in the private school should be maintained while the due process is decided. And this is something that is frequently happens, and it is frequently of issue as to whether or not the private school is going to maintain the placement while the mediation or due process is held. Now, another situation that may occur is that your child also was classified and was receiving services in the public school, but you did not believe that Mary was receiving an appropriate education, and so you removed her and placed her in Happy Private School, which was the school that focuses on students with special learning needs. And in that situation, the question comes up, is your school district obligated to reimburse you for the cost of tuition and to transport Mary to and from the private school? And that is a situation in which your rights under IDEA are much greater than they would be if it's a purely private placement. Whether you would get reimbursement would depend on whether the IEP and the placement proposed by your school district provided Mary with a free appropriate education. And if it did, then you would not be entitled to reimbursement for the private school. If the answer is no, it did not provide her with an appropriate education, then you may be entitled to reimbursement if the private school offered her an appropriate education. And this all comes down to questions of fact. And if the district doesn't agree to settle it, would mean that you would have to go through a hearing. Now, if you are removing your child and placing them in a private school because you believe what the district is providing is not appropriate and the private school is, you're obligated to give your school district written notice 10 business days in advance of the removal, and if you do not do that, a judge may deny reimbursement. Now, while your child is in the private school and you're going through the process to see if you're going to get reimbursement, in the meantime, your child can be eligible for the proportionate share services as well as some Chapter 192 or 193 services and the transportation services in the meantime. All right, so that covers what might be available. And remember, the private school can be either a religious school or a non-religious school. It does not have to receive federal funding. And then there are the different circumstances depending whether it's a pure private placement or a placement where the private school has been approved for the placement of students by public school districts and was placed there by the public school district, or you have placed your child there because the district was not providing an appropriate education and you are going to be seeking reimbursement from the district. So the second federal statute is Section 504 of the Rehabilitation Act of 1973, and it is a federal statute which prohibits a recipient of federal funding from discriminating against an individual with a disability solely because of the disability. So what is key to Section 504 is that the private school must be a recipient either directly or indirectly of federal funding. And Section 504 applies to religious and non-religious private schools as long as the private school receives the federal funding. So how do you know which private schools are recipients of federal funding? Well, a private school can receive federal funding through a lot of different avenues. So they could get funding for school lunch and breakfast programs, anti-drug programs, programs designed for at-risk students. If the federal government makes a grant to a nonprofit agency, which then allocates some of that funding to the private school, then arguably the private school is the recipient of federal funds. In some cases, courts have held that if you're getting the if the private school is getting some of the services under IDEA, then that money is coming from federal funds, and some courts have held that that is sufficient to constitute federal funding. There are cases that find where the school district is paying the tuition. The school district has placed your child in the private school and is paying the tuition, that constitutes federal funds because part of the funding that the district gets is federal funds. Sometimes this becomes a major fact-finding issue as to whether they're a recipient of federal funds or not. So Section 504 is essentially an anti-discrimination act, but it's also possible under it to get modifications and accommodations that would be beneficial to a student with Tourette Syndrome or any of the associated disorders. So an individual can be eligible as a student with a disability under Section 504 if the student has a physical or mental impairment which substantially limits the student in one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. And we're only going to talk about the first one, having a physical or mental impairment, which substantially limits one or more major life activities. So a physical or mental impairment is broadly defined and will include Tourette Syndrome and any of the associated disorders. And major life activities includes not just learning in a school situation, but it includes the ability to attend, to focus, to interact with others, walking, talking, breathing, eating, working, attending school, communication. It includes many of the major life activities. And you can be eligible for 504 in a school setting even if your physical or mental impairment does not impact your learning. It may impact other components of school. And substantially limits is supposed to be broadly interpreted. And the focus is on how the physical or mental impairment impacts the major life activity. So for attention deficit, for example, if you're saying you have attention deficit, it substantially limits you in the major life activity of being able to attend or focus. And so you look at, I mean, is it just a teeny little bit of limitation, then it may not make you eligible. But if you have attention deficit sufficient that you are asking for accommodations or modifications in school, it's likely to be substantially limiting you. Now, it is possible that a student who is not eligible under IDEA could be eligible under 504, because to be eligible under IDEA, the disability has to adversely impact your education, and you have to need special education. While under 504, you don't have to need special education to be eligible. You may just need modifications or adjustments. And as I said, the major life activity may affect areas other than learning under 504. So 504 will cover all kinds of physical impairments like diabetes, anaphylaxis, epilepsy, that may not be covered under IDEA unless the student also needs special education. And a lot of students with Tourette syndrome or attention deficit may not need special education either, so they may be covered under 504. Now, a difference, 504 does not require private schools to do child fine unless the private school has its own special education programs. And there are some private schools that do have their own special education program. Thus, if you believe that your child needs, and what you get under 504 in private schools are minor, what they call minor adjustments to the private schools program. If you believe your child needs minor adjustments, then you need to make the private school aware of your child's disability and what adjustments need to be made. And if your child is eligible for 504 and is in a private school, your child is not, or the private school is not obligated to provide special education or related services to your child. This is different than if your child is in a public school and looking for 504 services, because public schools have to provide special education or related services to eligible students under 504. So your services you're entitled to, your child is entitled, are reduced. Now, does Section 504 require private schools to admit students with disabilities? And the answer is yes, if the student meets the essential eligibility requirements set by the private school for admission to its program. So, Section 504 does not require the private school to change its essential enrollment criteria. If, however, the student could meet the program criteria with minor adjustments, then the private school has to make the adjustments. So let's look at some examples. If the student needs additional time because of the disability to complete an entry exam, then making this accommodation would likely be considered a minor adjustment. In other words, they could make adjustments to how they administer the entrance exam, but the fact that they have an entrance exam, that's probably not something that you could require them not to do. Modifying a no animal policy to allow a blind student to bring a service dog would likely be considered a minor adjustment. So minor adjustment is actually a little more than what it might seem from the words, but less than making a reasonable accommodation. So some examples: the Office of Civil Rights, which is where you would go if you wanted to bring a complaint under one place you could go if you wanted to bring a complaint under Section 504. The Office of Civil Rights found that a private school did not discriminate against a student with a learning disability when it would not admit the student because it did not have a math class to meet the student's needs. So in other words, they looked at the student levels in math and said, we don't have a class to meet your needs, and would not admit the student, and they upheld that. Okay, once the student is admitted, what modifications does the private school have to make? And as I said, they have to make minor adjustments. These could be extra time to complete schoolwork, seating preferences, larger print, lines on paper, menu changes, a journal to communicate, varying the instructional materials, an additional set of textbooks. Requesting changes to the academic criteria would likely not be considered a minor adjustment. Now, you could also get minor adjustments to the discipline policy. So if a student has vocal tics, then it would be likely be considered a minor adjustment to say that they wouldn't be disciplined for speaking too loud in the library or speaking at times that they shouldn't be, or not disciplining a student with a mobility impairment because it took them longer to ambulate from class to class, and thus they were often late. And there might also be minor adjustments made to the standards for disenrollment. So let's say you had a student with a chronic illness, and the private school's criteria is that we disenroll students after they miss 3 days. It might be considered a minor adjustment to ask if the student had a chronic illness, to ask that that time may be extended by, 3, 4, 5 days. I mean, I'm not going to say what would be minor, but they could extend it beyond 3 days. Now, generally speaking, the private school cannot charge more for the cost to educate a student with a disability than it does a non-disabled person, unless there's a substantial increase in the cost to the private school. Now, if the private school operates a special education programs, then it has to comply with some additional Section 504 requirements that apply to public schools. In that case, it has child fine responsibilities, so it has to evaluate, and it has to follow the process required at public schools, which has to do a comprehensive evaluation, and all of this is set out. It also has to educate the students in the least restrictive environment. It has to provide comparable facilities for students with disabilities. So if it operates a special education program, it can't put you those students in the closet and the rest get regular-sized classrooms, or have no chemistry lab for students with disabilities while the other students get one. And the students, it has to allow students with disabilities an equal opportunity to participate in non-academic activities and services. So there are some significant additional requirements on private schools when they operate their own special education program. Now, if you believe that the private school is discriminating against your child, do you have a claim against my public school district? And you may. And this is an important point because Section 504 prohibits a public school from providing significant assistance to a private school or another entity, it doesn't have to be a private school, that discriminates against the student. So if the public school is providing assistance, and it could be through chapter 192, 193, or other sources of funding from the public school system, and the private school is discriminating against that student, the public school may be obligated. An example of one OCR case was a student with a mobility impairment was unable to attend a local Catholic school because it wasn't physically accessible. So the diocese offered the student a program in a different diocese school, but one which was much further from her home, and then denied the parents' request for transportation. The Office of Civil Rights found that the absence of transportation services prevented the student from full access to the accessible school, and it was incumbent on the public school district to ensure that the diocese offered transportation at no cost to the parent. Another instance was the public school placed the student with mobility impairment in the private school, and it was then obligated to see that snow and ice were removed from the private school sidewalks sufficiently often that the student could access her classes. So it's important to keep this in mind because this can apply sometimes to transportation services that the public school is involved in providing. And then there are problems with the busing, or the busing won't accommodate the disabilities, then the private school may be brought in to see that the services are provided appropriately and accommodations are made. Now, another component of Section 504 is a prohibition against retaliating against someone who has advocated for an individual with a disability, and that someone could be the child themselves, but it also can be the parent. So if you participated in a complaint or investigation or a proceeding or a hearing, and then the school turns around and retaliates against you, that would be a violation of Section 504. And this illustration happens pretty often, where a parent was sending emails questioning the adequacy of the student's education, and then the school turned around and said, we will no longer respond to your emails. And OCR found that that was retaliation against the parent for their advocacy. Another example was a parent who also was advocating and was subsequently told by the private school administrator that his son's placement was being terminated because the administration did not, quote, like the parents, and the court held that the parent had grounds for a retaliation complaint. Okay, so that covers Section 504, and remember Section 504 applies to private schools, both religious and non-religious private schools, which get federal funding, either directly or indirectly. Now, a third act, federal statute, is the American with Disabilities Act. And the ADA has similar eligibility requirements, a physical or mental impairment that substantially limits one or more major life activities. So that's very similar. The difference with the ADA and its Title III that applies to public accommodations like private schools is that the ADA covers private schools which do not receive federal funding directly or indirectly. The limitation on the ADA, however, is that it does not cover religious private schools if the private school is controlled by religious organizations. And sometimes this turns out to require a fact-finding hearing to determine whether this is true, but many religious schools are controlled by religious organizations, so they are exempt from the ADA. And Title III of the ADA applies to nursery, elementary, and secondary private schools. It also applies to post-secondary schools. It also covers private entities that are primarily engaged in transporting people. And I put this in because there are all a host of issues that come up on school buses, whether your child is in a private school or in a public school. So the ADA covers principles like equal opportunity to participate, equal opportunity to benefit, and the receipt of benefits in the most integrated setting appropriate. And the ADA, like Section 504, cannot refuse to admit your child because of his or her disability. So it would be unacceptable and unlawful for the private school to say, we cannot admit your child because he or she has Tourette Syndrome, attention deficit, autism, cerebral palsy, or any other disability. I mean, to flat out say we cannot admit your child because of the disability would be a violation of the ADA and Section 504. Unlike a public school, however, a private school can set specific requirements for admission to its program, including academic requirements, but it needs to ensure that the instruments it uses to determine academic levels do not discriminate based on the student's disability, and that the private school makes reasonable accommodations when the student is assessed. So some examples, a student with attention deficit hyperactivity disorder who demonstrated significant discipline issues before they got to the private school was found not to meet the private school's conduct requirements unless the termination of the enrollment was upheld. But it also could be upheld not to admit the student in the first instance. And another instance was where the student cheated on the test and lied to his advisor, and so he was found to not meet the private school's core value of honorable conduct, and the termination was upheld. Now, one thing that comes up, if your child has a disability, what kind of medical documentation are you required to give? Well, the ADA prohibits unnecessary inquiries into the existence of a disability. And let's say that your child has various disabilities and wants to participate in activities offered by the private school. You are only obligated to share the information needed to ensure your child's safe participation in the activities. You don't have to share. Now, if a medical physical is required for participation in sports, which it is, of course you have to have that, but you don't have to share information about your child's disabilities that isn't pertinent and relevant to your child safely participating in those activities. The same if your child has ADHD, is taking medication at home, is not going to be taking it in school. You're not asking for any modifications to the policies, practices, or procedures, then you're not obligated to share medical information about your child's ADHD. Now, one of the questions, would denying your child the right to participate in a field trip to a Broadway play because of his or her Tourette Syndrome violate his rights under the ADA? And the answer is yes, because the ADA mandates an equal opportunity to participate in or benefit from the goods and services offered by the private school, and prohibiting your child from participating because of his or her disability would be considered discrimination and a violation of the ADA. Now, you could be prevented from attending if it would result in a direct threat to the health or safety of others, but this requires an individual assessment by the private school that there's a significant risk to others that cannot be eliminated or reduced to an acceptable level by reasonable modifications to policies, practices, and procedures. So it's not an easy thing to do. Now, a private school under the ADA has to modify its policies, practices, and procedures in order to avoid discriminating against an individual. They have to provide reasonable modifications to the policies, practices, and procedures unless they can show that the modifications would fundamentally alter the nature of the goods, services, facilities, privileges, advantages, or accommodations, or show that it would be an undue burden. A private school does not have to provide services of a personal nature, such as assistance in eating, toileting, or dressing, unless it provides those services to all students. But it can provide minor assistance, such as cutting up food or opening a drink container or something of that sort. And an undue burden is a significant difficulty or expense, taking into consideration the overall financial resources of a private school or its parent corporation or entity. So in other words, if you have a private school that is a part of a chain, then it's not just the school that your child is attending that's taken into consideration as far as whether it's a significant expense. You also look at the parent corporation or entity, the whole financial setup, to see if it's going to be an undue burden. Now, under the ADA, individuals can also get auxiliary aids, and auxiliary aids are available to individuals who have physical or mental impairments such as vision, hearing, or speech impairments that substantially limit the ability to communicate. Other individuals get reasonable modifications, but this covers, this auxiliary aid obligation covers students such as students with autism who have limited or no verbal communication, or other persons with communication impairment, so it can cover a lot of individuals. Now, the type of auxiliary aid or service that is needed to ensure effective communication needs to be provided under the ADA. And what is going to ensure effective communication is going to vary depending on the factual circumstances. Now, the private school also has to provide auxiliary aids and services to a companion of the individual with a disability, such as family members or friends or associates, if that companion is disabled and is someone with whom the private school should communicate. So here are lists of some of the auxiliary aids and services. There are note takers, written materials, qualified interpreters, assistive listening systems, qualified readers, all kinds of braille material, computer terminals, communication boards, all kinds of services. And this is important. They must be provided in an accessible format, in a timely manner, and in such a way as to protect the privacy and independence of a student with a disability. So if a student needs help taking notes, a teacher calling for volunteers in the front of the whole class does not protect the student's privacy and arguably would be a violation of the ADA. Giving a blind student a reading aid instead of an accessible electronic book to complete in-class reading would not allow the student to work independently, and so could be a violation of the ADA. So these are important components. Now, the private school is encouraged but not required to consult with the individual with a disability to talk about what type of auxiliary aid or service may make effective communication possible. So this is a little limiting. And a private school cannot discriminate against a student because of his or her known association or relationship with an individual with a disability. In other words, a private school cannot refuse to admit a child because his or her brother is infected with HIV. A private school cannot refuse to admit one sibling because the other sibling has Tourette Syndrome or an associated disorder. And likewise, a private school cannot terminate the entire family of students because it is terminating the placement of one student with a disability. You can't terminate everybody else because of their association with that child. And the same under 504, the ADA also has a anti-retaliation, and it's basically the same as what's available under 504. And the same under ADA as under 504. If the public school is providing support to the private school, which is discriminating against a student with a disability, that may subject the public school to liability under the ADA. And that's how sometimes pressure is provided on the private school to do what it's supposed to do, pressure provided by the public school. Now, of course, the ADA also has the accessibility, physical accessibility requirements, which I've covered here as to what those must be. And one other state statute, and it's at the end of the outline, is the New Jersey law against discrimination, which prohibits discrimination on the basis of disability and a placement of public accommodation that includes schools, regardless of their source of funding. But like the ADA, however, it does not cover any private school, which is operated by a religious or sectarian institution. So that basically covers the 3 federal statutes that may provide or do provide protection to students in private schools, and how they may be applied to a private school that is religious private school, a non-religious private school, a private school that gets federal funding, a private school that is approved by the state of New Jersey for the placement of children, and where you are have placed your child in the private school and are seeking reimbursement from the school district. So there are different circumstances depending on all those factors. So I think that ends the presentation. Do we have any questions?
Yes, we do. Thank you very much. That's a lot of information to try to absorb, I have to tell you, but it's really complete. So yeah, I'm going to start right in with questions. If the private school is receiving Title I services, and I'm not sure what Title I provides, does that validate the private school that receiving federal funding? So is everything that has a title in front of it validating that it's federal funding?
That would likely, yes, be considered federal funding.
Okay, and so I don't know how many titles there are altogether, but there's no distinction among those titles. Is it very narrow what the title provides so that it wouldn't apply?
Title I provides for services for disadvantaged students. So,
okay,
you know, it's
good,
like we're going to have Title II. We don't have Title II. We got Title I. But Title I is federally funded, so it would be federal funds.
It would be qualifying. Okay.
Right.
So,
right.
If a school district places a child in a private state-approved disability school, and that placement and the school district hold an IEP meeting without the parent, which results in removing your child from the program due to an absence, what recourse does a family have there?
Well, the parent under the law is to be given written notice of any IEP meetings and given an opportunity to attend the meeting. And if they cannot attend on the day that the district notifies them the meeting will be held, they need to tell the district that, and the district needs to reschedule it at a time they can attend. So if they have had an IEP meeting with only the public school representative and the private school representative there, then it isn't in compliance with the law. You can file a mediation or due process objecting to that. You may want to start by putting in writing to your school district that you did not receive notice of the IEP meeting, and you want them to reschedule it and hold a meeting at a time that you can attend, because you have a right to be present at the IEP meeting, and there are all kinds of issues that could be discussed at that meeting. Why is the child not attending? Are there other supports and services that could be provided so that the student would be able to get there? If you are in agreement that the placement needs to be changed, then you need to be involved in the discussion of what the alternative placement would be. So there needs to be an IEP meeting at which you are present and that you're giving written notice in advance of the meeting so that you can attend. And it's a violation of the law not to do that.
Okay. If a family gets reimbursed for travel and they receive the full amount all at once, what happens if the child gets sick and is on home instruction or out of school for a long period of time? Are they obligated to reserve that money aside and pay it back? How does that work?
I don't really know. I've never had that happen.
Okay.
It's not really I don't know. I don't know the answer if they would. It's hard for me to think that the state is keeping track of that, but I don't know.
Okay. All right. If your child is moving back to public school and your district of residence takes the action can your child be placed in another district, or do they have to go back to the district of residence?
Well, when the question is moving back, does that mean relocating back to that district, or you have removed the child from the private school and have re-enrolled them in the public school?
I would say, based on this, is they've been re-enrolled in the public school in their home district.
Oh, okay. Well, the public school could, with you at an IEP meeting, could decide that your child should be placed in the home district where you reside, or sometimes students are placed by their public school in other public school districts. So it's not uncommon for the IEP team, including the parent, to decide to place the child in another school district because that school district has a program which the home district doesn't have, or maybe the home district for some reason is filled, but usually it's because they don't have a program.
Okay, so there's no requirement that the student go back to the district of residence. It really depends on if that the district of residence has the space and the program for that individual. Okay.
Well, when you typically, unless there's been an IEP meeting to decide otherwise, when you re-enroll your child in the public school, your child will go there until such time as there's been an IEP meeting to decide a different placement.
Okay.
If you are having your child evaluated by the public school and you even in advance of the IEP meeting, or certainly at the IEP meeting, you can ask your district to look at what they have available, and you can also say to them, are there other options in other districts? I'm not sure that what I've seen here would meet my child's needs, but can we look at programs in other districts?
Okay. All right. We've gone long. I'm going to do one more question, okay? I have a question about lotteries. How do the lotteries work? Like, who supervises them? And another part of the question is, do preference...
Is a lottery in a private school?
Yes.
Well, the private school...
I assume yes. Let me put it that way.
Right. The private school would have its own policies and procedures on how it handles a lottery.
Okay. Then would students, is it weighted in any way based on what student can pay or so forth? Is it pretty straightforward up and up lottery, I guess is where
That's
this is going.
That's going to depend totally on the private school.
Okay.
I mean, if you could establish that the private school had a lottery in which they took off 10 points if you had a disability, because you had a disability, then that arguably be a violation of 504 or the ADA, depending on which are both applied.
Okay, but you need to...
private school sets up its own system for how it's admitting students.
Okay, can I just
that question is not coming from charter school?
Well, that's
lottery?
what I was just going to say. Could we just fold that into and just take another minute into charter schools then? So they have lotteries as well.
Right. Well, Newark has a whole lottery system, which I'm not intimately familiar with.
Okay. But I hear, I mean, we're in New Jersey, obviously. I hear them talk about lotteries in New York all the time.
Right.
For charter schools.
Right. Right.
So
they're going to set up, I mean, here, even if it's a charter, except Newark has its own system for lottery, which is a mammoth system, but it's going to be written down, and you'd have to look at, and a private school or a charter school who conducts lotteries should have it in writing, so you need to look at what the written procedure for the lottery is.
All right, then I think we will end it here. I'm going to thank you very much, Rebecca. That was really just loaded with a ton of information. I'm going to turn it back over to Kelly to tie everything up.
Thank you for joining us on our webinar on private schools. There is an exit survey which we need everyone to fill out. The webinar blog is now open and available for the next 7 days on the NJCTS website for any additional questions that were not covered in tonight's presentation. The website is www.njcts.org. Also, an archive recording of tonight's webinar will be posted to the site. Our next presentation, Disclosure Part 2, will be presented by Dr. Robert Zambrano and is scheduled for December 7th, 2016. This ends tonight's webinar. Thank you, Rebecca, for your presentation, and thank you everyone for attending. Good night.
Good night.